Age Matters, Strategies for Representing Juveniles in Adult Court. And this one is entitled Strategies for Keeping Youth Out of Adult Jails and Prisons, Bail, Sentencing, and Post-Sentencing Advocacy. I'm Vanessa Antone, Resource Counsel for NACDL, and NACDL is very pleased to present this series of webcasts on representing juveniles in adult court in partnership with the National Juvenile Defender Center, the Juvenile Law Center, and the Campaign for the Fair Sentencing of Youth. These sessions are funded by the Foundation for Criminal Justice and the Ford Foundation. Now, the main goal of these webcasts is to provide a training resource for attorneys that represent juveniles, especially attorneys that just represent juveniles in adult court on an occasional basis and really need this extra information when they are appointed to represent someone or have a case coming up. So please tell all of your colleagues who are unavailable to watch today and yesterday that all of these broadcasts will be on our website along with previous broadcasts in our juvenile web series. So without further ado, I will introduce our experts in juvenile law today. And for a more full background on each of our presenters, please visit our NACDL webpage for these webcasts. Debbie St. Jean is with the Maryland State Public Defender. She's seated here. Beside her is Erin Davies, who is with the Children's Law Center in Kentucky and works in Ohio. Cathryn Crawford, who is also the organizer of this webcast series, so an extra thank you to Cathryn, is a former clinical professor at Northwestern University representing juveniles and adults, including in capital cases. Cathryn specializes in representing youth in adult court. So I will turn it over to our panelists. Thank you.
Thank you so much, Vanessa, and thank you for hosting this series of webinars. I think the differences in juvenile and adult court can be very striking, and this is such an important proceeding that I'd like to thank you all for organizing this and for being here today. So we'll get started with a framework for our session. And the framework really starts with this idea that kids are different from adults. There's been a series of Supreme Court cases in the U.S. Supreme Court that have really established that kids are fundamentally different from adults. And this is Roper, Graham, JDB, and Miller. And these were discussed a little more in depth in the prior webinar by Marianne Scally. So if you want more in-depth information on those cases, you can go to that webinar. And these cases really establish that kids are different from adults, but these differences are not only chronological, but emotional, physical, social, and neurological. So things that you may not be able to see physically, things are still going on differently brain development-wise for these kids. These youth also have different needs than adults, which we'll get into during our presentation a bit more. So not only are kids different, but juvenile courts are very different from adult courts. There's a whole different terminology that goes with juvenile courts that has a parallel terminology in adult court, but the terminology is just the start of things. I think it's important to recognize that juvenile courts and the facilities associated with them, so juvenile detention, pretrial facilities, and correctional post-trial facilities, are specifically designed for youth and their needs. Adult courts do not have this specific design for youth. So adult courts usually don't factor in any adolescent development factors or any factors that may make your client less culpable because of adolescent development. They also don't have these facilities designed for youth, which we'll get into a bit more later. And they also don't work for youth. The research on this shows that on the whole, youth who are transferred to adult court are 34% more likely to reoffend when compared to youth who are retained in the juvenile system for the exact same offense. So if you take two kids, same circumstances, one goes to adult court, one stays in juvenile, the youth who goes to adult court is actually more likely to recidivate than the youth who remains in juvenile court. Now you can argue that creates more victims, it increases public safety, so that's, I think, a very critical point to realize that this court system does not work for these youth.
What do these differences in the courts mean for you as a practitioner representing children in adult courts? I can tell you that it's an uphill battle for you. The court is going to be treating or inclined to treat your child as an adult. And it's really your job to point out the many, many ways, as Erin suggested, that these children are not just miniature adults. And their age is far more than a chronological fact. It has to do with differences, as Erin indicated, neurologically, socially, physically, emotionally, nutrition. I mean, it just goes on and on. And for anybody that deals with children, this is going to become very self-evident to you. So what do you need to do? When we were discussing this not long ago, we came to the conclusion that every state has different practices about how these children end up in adult courts. Every state has different names for what these things are called: transfer, reverse waiver, binding over, as I've learned. So it's not really important what it's called. You have to understand what's going on and how it's done. And some states have very complicated processes for these decisions. Others, kids are direct filed by virtue of an age, a statutory enumeration of felonies, automatically lands a kid in adult court, and then the person representing that child is charged with getting the child back to juvenile, waiving back, transferring back, reverse waiving, whatever, again, what it's called. I guess the point here for everyone is that if you represent a child that is standing in adult court, you really have to understand how your state and your state's statutes, court rules, evidentiary rules deal with these proceedings. When it occurs, what occurs before the actual transfer, and does your state have any ability, or do you have any ability in your court rules and statutes to take a child charged as an adult and move that custody physically to a juvenile detention center pending the outcome of any of these hearings? So it's really important that you become familiar and talk to people who do this in your jurisdiction. There are public defender offices like ours in Maryland that has a specific unit that deals with these children. Reach out to those individuals, collaborate, share information. They sometimes put on trainings, but it's really important to know what's going on in your state. The other thing that is really critical when you're doing these hearings is to understand adolescent development. And as Erin indicated moments ago, the prior webinar dealt with Dr. Woolard and Marianne Scally from the National Juvenile Defender Center, and they went through and explained those differences, the differences between children and adults really well. I can tell you, right after, years ago, after Roper v. Simmons, it was so exciting as a practitioner to read that case. It was even more exciting to read the brief that was submitted by the American Medical Association and the American Psychiatric Association. And if you think about that, these are groups that comprise hundreds of thousands of members who've come together on a science, on a sort of an explanation of a science to the Supreme Court to really change significantly how children are treated by the Supreme Court and should be treated by your court. And interestingly enough, as a new practitioner way back in the day, I was always surprised when courts, I thought judges just knew everything and there was nothing that they didn't know, and I was only sort of, plumping up what they already knew. And I've come to the belief as a practitioner that it is surprising the numbers of individuals who don't know anything at all about this research, don't know anything at all about the substantive differences between children and the areas that it affects, and we'll go through that a little more. Just touching briefly, as I said, this was explained in great detail in 2 prior webinars, and it's really worth your time because you're going to have to explain this to the court. You're going to have to educate your judge or judges, masters, whomever hears these hearings, about this difference. So I think the easiest thing, and probably the quickest technique that I could tell you or thing to do is to get this American Medical Association's brief. And if you click on Roper v. Simmons, most online sources for the case have the briefs, and if you can extract that brief, read it, it's very, very interesting, and it's really, truly a gift that is very, very helpful to explain why kids do these really risky, bizarre, ill-considered things that end them up in an adult court. What else do you need to do? When you represent a child in the adult court, it's kind of like a mitigation in a capital case. You have to start to gather as quickly and as early as possible as much information as you can retrieve on these children. When you talk to your client initially, there's a number of things, and we'll go through these later, but just think of the ways in which the sources of information that kids have that adults don't really have, and that a lot of that is school-based information. Most of these children have something called an individualized education plan, an IEP. You're going to have to understand what that document is, why it's created. It usually represents that the child is emotionally disturbed or has a number of mental health diagnoses that prohibit the child from obtaining an education. What that means for you as practitioners is that there are a number of people who've evaluated this child, psychologists, guidance counselors. The school is charged with, under federal law, of amassing huge amounts of data on exactly where this kid is educationally. So you may be standing next to a 16 or 17-year-old in an adult court who actually functions at a second grade level, reading, math, who has an IQ that may be borderline. And the differences that, the neurological differences that we were talking about early, when you factor in mental health disorders, that only exacerbates the already significant differences between adults and children. So you're going to start to get this sort of body of evidence that you want to be able to say, you want to be able to put forth at the court, even at a bail or bond hearing. So you're going to look for school records. You're going to find out from your child whether or not that child has had any juvenile court involvement. And again, each state is different. But I guess the significant thing is this. If a juvenile court has this child either under jurisdiction now or under probation or been through programs, again, this is an invaluable source of information about a psychosocial sort of history of what your kid is all about. You should start talking to, find out from your client whether or not they're in the dependency system. The dependency system, again, that means that circumstances were so egregious that the state reached in with a long arm and plucked that kid out of its home and committed it to another system in the juvenile world, the dependency system. That child is then going to have social workers, they're going to have case managers, they're going to have a treatment, an individualized treatment program, listing what their specific areas of treatment needs are. These are all hooks for you. They're just great resources. Talk to these people and get them kind of on your side. Like any witness in a case, you're going to try to, see what that person has to say, and see whether or not they're going to be helpful to what your end goal here is. And your end goal in whatever proceeding you're calling it is to get that child out of the adult court and back into juvenile.
I just want to make one point about gathering records, because one of the challenges that a lot of adult offenders face is because you're not familiar with the juvenile court, either on the delinquency side or the dependency side. Sometimes court officials or clerks will tell you that you can't have this information, that it's confidential, and you have to be very firm in saying, these records belong to my client, I represent that child, and I want these records, and if you're not going to give them to me, I'll get a court order to do so. Similarly, when you first meet with your client, getting those release of records, authorizations from them, and even though they're in adult court, their parents, is critical, particularly because when we're talking about dependency records, for example, It's not just the client that is subject to those dependency proceedings. Oftentimes they have siblings or parents who are named as the respondents, and the various courts or administrative offices or bureaucrats that are releasing these records are required under law to have releases from everybody who's involved. If you can't get releases from everybody involved, don't give up. Say, well, then redact the stuff that relates to the father that we don't know where is, or the brother who can't give us authorization. But these records are so critical for you at the various points of the proceeding that they're going to discuss, that don't take no for an answer. And prepare to ask your judge in the criminal proceedings for those records, but be sure to do so in a way that doesn't give access of those records to the state, because that's the other thing. Just because you're entitled to them does not mean that the state's entitled to them, unless you intend to use them in some manner or another. And before you disclose those to the state, you will have to get your client to consent to that.
Cathryn raised a very significant and sometimes very thorny problem. And in some jurisdictions, so I guess the sort of the down bottom line on this is you're going to have to learn about your state's confidentiality statutes and whose records they are. In Maryland, for instance, the dependency and delinquency records are court records. So they're not, you have to go to the juvenile court and get the juvenile court's permission to use those records. Even if you get them, let's say your client, and I don't want to spend too much time on this because this is a whole sort of wild area, but even if your client has those records, your confidentiality statute may require you to get a court order before you can publish those or use those in another proceeding. So be mindful of that, and that's sometimes a tricky thing. Okay.
So today we're going to focus on three particular areas, including bail, sentencing, and post-sentencing advocacy for youth and adult court.
All right, so bail options. What are the options available for your client? I've been doing this for a while, and I've never had a juvenile charged as an adult able to make the hundreds of thousands of dollars of bail that the court will impose. It's an option, and we're going to go through and try to tell you maybe there are ways in which you can get a reasonable bail, or you can get a community release for your client. But typically, these cases involve very serious felonies. You would be hard-pressed, and really, kudos to you if you can, convince a judge to release your client on some de minimis bail or community release. So what do? You let the kids sit in the adult detention center, because we're talking about children sitting in an adult detention center. Check your jurisdiction against statutes and rules to see whether or not they have a mechanism that allows you to move a child pending the adult transfer hearing into a juvenile detention center. It's like the same kind of place, except children are housed there. It's the same level of security, and it is much better for the child, as we will continue to explain later. I think somewhere in the website are sample motions, and there's a sample motion that's in there in which we use in Maryland to try and move a child that is charged. So we're talking about the initial bail, bond hearing, whatever it is you call it, standing up and saying, Judge, this child next to me is 15 years old, and the court may be interested to know the fundamental problems that this kid is going to face in the adult detention center. So in your initial interview with your client, you're going to try to be finding out just sort of a bunch of personal, particularized information about that child to put in the motion. And if you look at the sample motion online, I'm talking about my child's IQ. I'm talking about what grade level he reads at. In this instance, the young man was, 16 years old, and he read at a second grade level. He had a borderline IQ. his first night, because bail, of course, was the next day, the bail hearing. So his first night, he'd already had been beaten by a group of individuals. Had a black eye. They took his food. So those are situations that are really kind of important for a bail judge to know. Erin also is going to talk about later on all of the differences between the adult system jail, the detention center for the adults, as opposed to the detention center for the children. So that means that another task that you're charged with is actually going to the jail and seeing where these kids are housed. I don't know if your jurisdiction allows you to go into these facilities, actually into the cell area, the area where these people sleep. But if they don't, then seek an order of court, or maybe you speak to the superintendent, figure out a way in which to get in there so that you can actually eyeball how these kids are housed. Do they have sound and sight separation? Some adult detention centers make an effort to keep kids who are under 18 separate and apart from the adults. Others don't. Even if these children are kept separate and apart from the adults, in Baltimore, we just went through a huge thing at the detention center for Baltimore City. These children were being housed in large dormitory type settings, in a large cage with rows of bunk beds, and there were 3 floors of them. In the evening, there was only one guard that actually patrolled from floor to floor. So the children would know that when the guard left their particular floor, there was no adult supervision, no supervision of any kind. That resulted in a number of beatings going on, either for shoes, for food, for any reason. So the smaller, more vulnerable kids were really having a hard road to go and faced considerable dangers. You're going to have to know those differences. You're going to have to know how those kids are held in the adult system. And on the next day, you should go and probably try to visit the juvenile detention facility and ask the people there questions about how are these children segregated? Are they... And I won't go into this because Erin's going to go into this later. I guess the important point is to note that there are significant differences between these 2 types of facilities.
I just have a question. You mentioned the sound and sight separation. Can one of you speak to the federal law that governs that?
Well, so federal law actually speaks about youth who are in juvenile court, and that they cannot be placed in adult jails except in very limited circumstances. It's like 6 hours for certain things. But those sight and sound separations don't apply to youth who are in adult court unless your state has a specific law on sight and sound separation of youth. And a lot of states will have that law. Ohio has it. But the JDDPA restrictions actually don't apply to youth who transfer to adult court.
So, but as you said, some state laws do, and also people are starting to increasingly make arguments that it should apply.
Yes.
Because of what we now know about the developmental differences, and also because some of the things that you're going to be talking about in terms of the different dangers that present themselves when youth are segregated or are kept in the same kind of facilities as adults. So it's one of those laws that hasn't caught up with the science, and it seems to me that if you are in a state that does not have extend those protections to juveniles who are transferred to adult court, we should nevertheless be making those arguments from an equal protection standpoint, from whatever kinds of creative ways that you can put in front of the court, that it doesn't make sense from a developmental perspective or from a social perspective to have these children in with these older people.
Right. And so segueing from that, in the bail determination, I think it's really important to ask, why is jail so bad for kids? I mean, I think we kind of know from a common sense perspective that it is, but there's actually specific research on why jail is so bad for these youth. And the first one I think is really the most important, and that's suicide risk. And the data shows, and I can't emphasize this enough, that kids are 36 times more likely, not percent more likely, 36 times more likely to kill themselves in a adult jail than they are in a juvenile detention facility. So think of that, I think of it in the context of what are you sending this kid to before they are even found guilty. And there's that piece. There's also research that shows that kids in jails are at great risk of physical and sexual assault in these facilities. The National Prison Rape Elimination Commission found that more than any other group of incarcerated persons, youth incarcerated with adults are probably at the highest risk for sexual abuse. In adult jails, kids are often unable to access required state programming, so compulsory education laws, compliance with the Federal Individuals with Disabilities in Education Act that requires youth with IEPs, as Debbie mentioned earlier, to get education. All of that goes out the window in adult jails because they aren't specifically trained to deal with these youth. And then jailers also, as Debbie was mentioning, face they're between a rock and a hard place of putting these youth in the general population where they know they'll have these increased risks versus isolating them. We have a young man in Ohio who's been in isolation since March. It's now September, so he's been in complete and total 24-hour isolation for the past 7 months. And then we wonder about the suicide risk numbers. And I think it's important to note that the research shows that the average length of stay for youth in adult jails is 6 months. So this is not a week issue, it's not a couple days issue. This is half a school year for kids that are missing out on time-limited access to programming. For example, we had a young man actually in Ohio get out on bail who was a senior in high school and was able to attend school under house arrest and graduate from high school. And if he had not been on bail in the same situation in the jail, he would have just missed the second half of his senior year and would still be there as his case continues to be ongoing. So think of it as this kid could graduate or could miss out on that school that he will never have a chance to go back to because he had now aged out of the system, essentially. So while you're, in terms of investigating your jurisdiction's jail practices, where do you look to find information about this? Oh, I'm sorry. First, we're going to look at things that you should be looking for. And we put a pretty comprehensive list up there. But the first is housing. So are the youth housed in dorms? Are there enough youth to do a youth-specific unit, or are the kids in isolation? I've also seen pods where kids there's a day room, but then there's individual cells, and kids will be isolated within those cells and allowed in and out of the day room for a couple hours, depending on how many other kids are in the cells, which is a form of isolation. You have to really look at that out-of-cell time and how much recreation time they're getting. Some kids will spend 24 hours in a dorm, 24 hours in a cell by themselves, and jails have been pretty upfront about that with me if you ask the question. You also want to ask about education. Is your client getting education? If so, how many hours? How is it being delivered? Is it being delivered by trained teachers, or is it being delivered by computer? So you'll want to ask that. Are they able to access special education services? Staff training, you'll want to ask if staff are specifically trained to deal with youth. And if so, what's that training like? Is it 8 hours that they get? Is it ongoing, kind of professional development training? What does that look like? Discipline and de-escalation, I think this is really important. So when an incident arises, how does the staff deal with that, and particularly for youth? Are there special policies and procedures in place to de-escalate that youth? the possibility is definitely there in jails for isolation to be used as discipline, for use of pepper spray, for use of very damaging responses to normal acting out teenage behavior that the staff will not see with adults. You want to know medical and dental health access, including access to youth-specific, pediatricians and dentists, that kind of thing. Mental health, are there youth-trained mental health staff available? Can youth access medications in appropriate dosages? Food, youth have different caloric needs than adults, especially growing boys. If any of you have teenage boys in the house, I'm sure you can relate. And then really this fear factor, is the youth afraid? Can the youth sleep? Have they been attacked, threatened, intimidated by anyone in that facility? What's it like for them? Do they watch their back all the time? Especially in the dorm settings, we see a lot of that, where kids are really afraid and are getting their food taken or getting their things taken. So now, how do you find that stuff out? I'm sorry. Okay, I'm just going to skip ahead for where do you look for this jail practice information. I think the number one place is the client interview, where you really talk to your client, ask them these questions. They may think that it's normal for things to be going this way, but so really dig into, okay, ask obvious questions of, wait, so I think I understand you say you're in your room all day. Does that mean you get out of your cell at all? And the kid will, sometimes it takes pulling that out. You can also look at your state laws, as Cathryn was saying about the sight and sound separation. Also look at the jail policies and procedures, keeping in mind that this will be a floor and not a ceiling of what goes on in those facilities. So those will be the bare minimum requirements that the jail should be following. You can also make Freedom of Information Act requests, which will be different by states, but ask, does the jail have specific youth policies and procedures? You will probably get a FOIA response that says no, which is very helpful, actually. Have other attorneys done lawsuits on jail conditions? We have a disability rights group that's brought a lawsuit against our jail, so we can, we could use that information. Also talking to jail staff, I find that they're relatively forthcoming depending on who you talk to. Even if it's just a question here or there, you can get information. And then other attorneys with clients in that facility also. So I'm going to go and now compare the jail practices to juvenile detention. Keeping in mind the big picture here, that these facilities are designed specifically for youth. And they're designed to do the function of the jail, but with this youth-specific focus. And it's important to note that juvenile detention facilities hold a wide range of youth, including a co-defendant, potentially, on a youth transferred to adult court, just by virtue of a couple days separation in age. So it's important to note that these facilities are designed to be secure and provide public safety for all types of youth, from an 8-year-old to an 18-year-old. So they're used to dealing with different ages, sizes, maturity levels, impulsivity levels. They know all that stuff. They're trained specifically to do it. The staff is trained. They also are, they provide youth-appropriate programming. So often they will have teachers who are qualified, highly qualified, and used to providing services in this kind of setting. They can also do youth-specific screenings to screen out suicide risk, mental health risk, substance abuse risk that jails won't be able to do. And they can have youth-appropriate responses to those screenings. And I think one way to look at this is to maybe do a FOIA of your juvenile detention facility's schedule for a day versus the jail's schedule for a day, and literally do a side-by-side of, okay, what does a typical day look like for these youth? And that can be really enlightening.
And can I just, when you say enlightening, are you suggesting that we are going to be presenting these two different schemes, these two different detention schemes to the court to help them understand the differences?
Yes.
Okay. And could you explain how we're going to do that and why?
Yes. So Debbie, I think is.
I think I can do that.
Yes.
At a bond hearing, if I'm trying to move a child from the adult facility to a juvenile detention facility, I will enumerate all of these areas that Erin just went through. The housing differences. In other words, you walk the judge through what happens to a kid in the adult. So your client's arrested and charged as an adult. He gets processed, fingerprinted, photographed, maybe not, sees a doctor. They really don't care what their mental status is. They don't care if they're, maybe the kid is high or drunk. They don't really, they're not really hard pressed about that. As opposed to going to a juvenile facility, if the court makes that motion to move the kid, immediately upon entrance, that child is subjected to a full mental health screening. They use an evidence-based, validated screening instrument to define whether or not these children have mental health diagnoses, are suicidal, or at risk for self-harm. They then go from there to a full medical exam. They actually see a doctor, and the doctor asks them questions about whether or not, for instance, in Baltimore, there's a significant lead paint poisoning problem. So there's questions about whether or not this child's been exposed to lead paint. That causes neurological problems, etc. Does the child have an inhaler? Are they asthmatic? Excuse me. In Baltimore City, in the Adult Detention Center, the Department of Justice came in a couple of years ago for really deplorable conditions of confinement. And when we were looking through those documents, the numbers of deaths associated with asthma-related concerns, because the air was so poor. There's no ventilation, there's no air conditioning, and for significantly compromised asthmatics, their chest starts to constrict and they can't breathe. And when we do these things in Baltimore in the summer, we actually get to go on to the unit where these kids are held. There is no air conditioning. They have a fan in the window. There's about 60, 70 kids in a large cage. And I can tell you, it is wicked hot in there. And when you're sitting, after you've peeled down as many clothes as you could possibly peel off you, you're sitting, I'm listening to that child talk. I'm listening to whether or not there's any asthma-related rattling in his chest. So I can describe to the judge, you are putting this child at risk because the jail doesn't have air conditioning or ventilation. Kids have died in this facility because the medical unit doesn't respond fast enough with an inhaler. So, in answer to Cathryn's question, yes, you say to the judge, let's walk through what happens to him in the adult facility and what happens to him in the juvenile detention. So, not only are they screened for all of these mental and physical conditions, they're then assessed according to their age and the level of their crime. There are pods for each of these sort of categories of kids. So, usually the state will stand up there and argue, Judge, we can't put this 16-year-old murderer in with a 12-year-old shoplifter. Well, in fact, that doesn't happen. Juvenile detention facilities are pretty diligent for their own liability purposes of segregating these children and putting them into the appropriate pods. So once they're there, they have access to treatment. In other words, a mental health provider, even though we're talking pre-trial, before anything has ever happened, they still have access to programming. They still go to school. They have the ability to see a doctor, usually on staff, a mental health provider on staff. If they get jacked up, one of their co-respondents or co-defendants is actually in the facility, staff there know exactly, they've been trained in how to de-escalate these children. Point out the difference to the court that we had an incident again in Baltimore where there was some poof-a-raw going on in the middle of the night with these kids in the dorm, and the jail's response was to spray every child in that dorm with pepper spray. So for the kids who weren't involved in this, they're also sprayed with pepper spray, which hardly seems, when you look at when we talk again about the developmental research, children are vigilantly concerned about fairness. And so, getting sprayed by pepper spray, not so much. That causes problems. Then they become disciplinary problems because the process isn't fair. And you can pull in the developmental research to explain to the court why that happens with these children. So there's a vast difference of staffing ratios. In your juvenile facility, I think OJJDP requires 1 staff for every 8 children. So if you're on a pod with 16 kids, there's 2 staff members there trained in how to deal with these kids, and there's programming. The more you leave these kids lounging around in a dormitory with nothing to do, the more mischief and shenanigans will go on out of sheer boredom. If these children in a juvenile facility, there's regulations on how much large muscle exercise they should have, what they eat, when they eat. If they're really hungry, they get to have a snack because their nutritional needs, as Erin has described, are vastly different. The adult facilities, they don't know for this. They don't know about kids. And I want to just mention something else because it's coming into my head. When you talk to these adult jailers, sometimes you can actually get them to come to court and to talk about the problems that they pose, that these kids pose for them in the adult corrections situation. Believe me, these people don't want these kids. It's a very difficult job for them because they don't have the resources, they don't have the staff, they don't have the money, they don't have the programming, they are not set up to deal with children. I think that answers the question, right? So you're going to focus on showing the absolute differences between these two, and they aren't de minimis. They are extraordinarily different.
I just want to make a point about that, about preparing your client for these arguments, because you are having to point out the potential horrors of adult jail to the court, and the fact is that the court may deny your motion, and so it's really important to explain to the child why you're making these arguments, that it's not as you're going to talk about the worst case scenario, but don't be freaked out, because if you are put in there, you and I can work together to develop ways for you to avoid some of this stuff, because we just have to remember that the clients are listening too, and we want to make these points real for the judge, but in doing so, we don't want to traumatize our clients and make them think, holy moly, I'm in big trouble.
And their families, too.
And the families, exactly. Yeah. And that's no small matter. And I know there's another webinar about how to discuss these things with your client, because later on, we're going to be delving into this child's, most intimate and private matters in front of a courtroom full of people, and you have to really prepare this kid for this, because kids don't want their business aired in front of everybody and their dog. They don't want to feel like people are feeling sorry for them, or that they've got some kind of, particularly the cognitively impaired ones, they're going to have difficulty even understanding what you're talking about in a lot of ways. So Cathryn and Erin are right. You've really got to take some time to sit and talk with these kids and make them understand why you're doing what you're doing, and what it means to them and to their families. So, yes. And that takes time. It's not like saying to an adult, look, dude, you got the following options. This is not how this works. These children, it takes a lot of time. One, they won't trust you right away. You're just another, adult telling them what to do, what's going to happen, and you've got to explain to them, as I try to say, and you've got to use it in terms that they understand. I was trying to explain to one of my children one time about, the other thing is, please instruct them not to talk to people. Kids want to talk about, what they did and why they did it, and they want to share that with anybody who will listen to them. And there'll be a number of individuals, particularly in the adult setting, that may have occasion to hear what your client is saying. We had a very bad problem at the Baltimore City Detention Center because the state's attorney was getting the phone records, the recordings, phone calls that these children were placing to their parents when they were first arrested. I mean, that's just wrong on so many levels. But when you get to your kid, probably one of the very first things that you need to explain to them is be quiet. Do not talk about this to anybody, even your parents, because there is no parent-child privilege. And, you know, a state can subpoena a child's mother or father and get them to recount exactly what the kid said to them about any number of issues. So make sure they understand, be quiet. I'm off on a tangent, sorry.
Yeah, so
Let's go.
while we're moving to the next session, I mean, the other thing that I just wanted to point out is as you are making these arguments, presenting this information to the court about the differences between the adult and juvenile facilities, you're also helping insulate the client from consequences if he does get in trouble in the adult jail, because you've already presented evidence to the court that relates to the jail's incapability of appropriately addressing these kids. So if your kid does end up in adult jail and he gets in trouble, you may be able to mitigate a little bit for sentencing purposes. And the last thing that I'll point out is that some states don't put the kids automatically in adult jail. Some of them start them out in the juvenile detention facility and only move them when they turn a certain age. So you can start developing your arguments for preventing the transfer to the adult facility when their birthday is coming up. And it helps if your client has successfully adjusted to the juvenile facility, or in the instance of a kid that would automatically be placed in a jail, an adult jail, in a jurisdiction that doesn't let them start out in detention. If your client's been in detention before and did well in detention, trying to use that as a basis for preventing the placement in the first place.
Okay, I think the next thing we're doing is presenting the evidence to the judge. And again, all of this information that we've been talking about, you're going to need to know whether or not the rules of evidence in your jurisdiction allow you just to put this evidence in. Can you just stand up and proffer what we've been talking about, or do you need, letters or affidavits, live witnesses? I think most jurisdictions, and I'm guessing on this, but it would seem to me sort of to make sense that there's sort of a looser evidentiary standard, because these bail hearings, bond hearings happen very, very quickly. Again, you're going to make a motion to move your client. This is your opportunity really to do a great thing for this kid, and that is to get him back into a juvenile facility pending his transfer or her transfer hearing or reverse waiver hearing. So there is a sample motion attached somewhere in that internet, and that explains essentially the kinds of things. It sort of incorporates Erin's statistical research about what dangers these kids face. So you are, in answer to Cathryn's question, you are comparing the two facilities, and then you're also talking about the particular characteristics of your kid. Why does this kid merit going back into the juvenile system? And you can always find information that's really, sort of heartbreaking to a court, particularly if the kid has been involved in the dependency system. I mean, that really is the most vulnerable of clients. They've already been removed from their homes. So you're going to try also to call experts. All right, so who are you going to try to find for this? Well, if your state has any groups, child advocacy groups, governmental groups that monitor the conditions of confinement. We are fortunate in Maryland. Our little group does that on behalf of our public defender clients. The Attorney General has a group of individuals that go through and monitor. And then, of course, we had CRIPA in, the Department of Justice, on a CRIPA complaint into the Baltimore City Detention Center. So they have federal monitors which appear every now and then, and they write reports. So that's a very helpful thing, and they will cover, our CRIPA reports covered everything from rodent droppings in the food at the jail to the temperature of food stored in the refrigerator and why were all these prisoners getting sick. That's beautiful. It's a gift. It's a lovely thing to tell a court that, because I can tell you, most judges have never, ever, ever been in an adult prison facility or the jail, or ever, ever been in a juvenile detention facility. So you know, pictures are good, although we had a lot of yang from the Division of Corrections about taking pictures in the Baltimore City Detention Center, mostly because I think they were afraid of getting sued. But consider it and be creative about how you're going to show the conditions. Call witnesses. Maybe there are correctional officers, the one at night who's tired of bouncing from floor to floor and, you know, fooling around with these kids in the middle of the night, and they don't have enough staffing. They may have complained to the superintendent about the staff shortages, right? Like the officer that we were speaking to was really aggrieved that she had to go up and down stairs all night long to monitor 3 floors, as opposed to sitting in her chair in the control booth, flicking the switch and watching her little TV. So she may be willing to give you an affidavit, or she may be willing to testify, and use your developmental research, all this stuff that comes out of the differences between adolescents. I'm going to remind you what those are, and I had to write them all down because I forget them all the time, and I deal with this stuff all the time. We're talking about the prefrontal cortex of a child's brain. And I can tell you it was an epiphany when I read this, because it just explains so much about kids in a scientific, neurological, absolutely applied sciences manner. So the kid, the prefrontal cortex kind of is like the CEO. That's how it's described. It sort of takes information from all different areas, sorts it out, and then puts it, you know, into sort of behavioral, appropriate behavior. I've had this science explained to me like this. A child's brain is really like a very souped up hot rod. Unfortunately, it has no brakes. And that's really how this works. So the developmental research dealing with the differences between children and adults, it affects their ability to exercise judgment. Impulse control is another one. They're very impulsive. They have relatively little ways in which to curb those impulses. Problem solving. They have difficulty with problem solving, organization, and planning. I mean, this affects all manner of ways in which children interact in situations, in social situations. Not even thinking about the jail as a social situation, but their ability to process this information and to react with considered judgment, taking a pause and weighing the risks of, geez, this guy is really making me mad, I'm just going to hit him, and that's going to stop, right? That's how kids respond to these kinds of things. They're not thinking about it in terms of, as much as I'd like to hit him, I'm going to have to face, you know, the following things, and it's going to affect my ability to get my transfer, and my lawyer's going to be mad, and the judge is going to be mad. They're not thinking about anything like that. They're thinking about bang, that's it. So they don't anticipate the consequences.
And I think that the point that you were making earlier is that the juvenile facilities are much better designed to take all of these considerations, take all of these facts into consideration, and so prepare an environment that is responsive to those kinds of characteristics.
Right. Mm-hmm. Like a perfect example, kids scrap all the time, and they'll be sitting around playing cards in the juvenile facility, like in their free time, they'll be playing cards, and they'll be scrapping about something. Somebody will be saying something about somebody else, and the next thing you know, there's a couple slapping going on, and instead of getting sprayed with pepper spray and put into isolation, a juvenile correctional person will come over, sort the beef out. What's the matter? Don't talk like that. Oh, geez, apologize. You apologize. What game are you playing? They distract, deflect, and get the kids back onto the deal. They don't bring in, the SWAT team with big covered masks and canisters of pepper spray. They try to sort this out. So that's really what you're going to be trying to figure out. How do I explain that to a court? And again, there's lots of articles, there's lots of webinars, There's a brief out of the Roper case that explains this, and you're going to have to start to understand it and explain it to a court.
So we're going to do a sample argument, but we'll hold off till the end, just so we can get through the material, and hopefully we'll have time to go back and do that. We had talked a little bit earlier, Debbie had talked earlier about how to get information on your case. This just kind of runs through those sources that we had discussed earlier. So now we'll move into sentencing. But before we get into adult court sentencing, again, this goes back to really knowing your state-specific laws, that in analyzing any plea bargain that you all may get on behalf of your client in adult court, you really have to understand if your state has any mechanism that would allow the youth either to be returned to adult court through a reverse waiver process.
You mean juvenile court?
Yes, I'm sorry, from adult court to juvenile court. Through the reverse waiver process, or if there's some kind of blended sentencing scheme where a youth could have an adult court sentence that's stayed pending their success in a juvenile court sentence. So just make sure to check that. For example, in Ohio, our law says if a youth is bound over under certain circumstances and they plead to a lesser offense, they can actually, in some cases, automatically go back to juvenile court. So that's really important to know as you're working out a plea bargain and understanding those parameters and rules. We're going to move to what to ask the judge for.
All right, so in a transfer reverse waiver, you're at a sentencing, you're really asking the court to, again, as Erin indicated, whether or not there's any ability for that judge at that time to return the kid to juvenile court. And this morning, during this other webinar, Cathryn covered a really interesting area that I think has just a lot of bang for your buck. In Maryland, we don't have this problem because we have a sort of a procedure. And I want to give you just a little synopsis of a sort of a quandary that we had in a case not long ago. It was a 14-year-old boy, and he was charged with murder, first-degree murder. Because he was 14 and that was murder, they charged him as an adult. We progressed along through this case. I lost the initial transfer hearing, and then we were having this discussion, about having time to do pleas. There wasn't vertical representation in our office at that point, and another lawyer was taking the trial, this first-degree murder trial, and there was a plea agreement, and so we got that sort of stopped, and we actually tried the case. We beat all of the charges, which gave the adult circuit court jurisdiction. So in Maryland, and I'm thinking, yippee. So that gave us the ability, under Maryland, there's something called a second chance transfer. And then that occurs when, after trial, if you've managed to get not guilties on the charges that gave the adult court jurisdiction, you have the ability to do another transfer hearing, a second chance transfer. And we were successful with that. But Cathryn raised this morning about if that's the situation in your case where you have beat the charges and you don't have a mechanism, an actual mechanism in place to allow the court that, you should argue that nevertheless. And think about creative ways in which to place that and all the different ways, all the different information that you can use to convince the court to do that. You've got this developmental research. You've got lovely Supreme Court cases all talking about a juvenile's implied right to rehabilitation. Oh, and guess what, Judge? There is no rehabilitation in the Division of Corrections, or you're in the adult prison system, and you're going to have to know what those differences are. You're going to talk about how because of all of these differences with kids, because this court now wouldn't have had jurisdiction had the child been charged with the appropriate charge, we wouldn't even be before the court. So just because your state doesn't have a mechanism like a rule or a statute that says you can do that, really try to devise a clever and useful argument to try to convince the court. Even so, let's move him back. There may be, the court may have wide discretion and ability to craft a sentence, and that's an individualized determination for that particular child. So, again, I'd encourage you. The one this morning was very, very good about a creative motions practice and how to, different apprende challenges to the court about sentencing and how we have a right to jury trial. In my state, juveniles don't have that at sentencing. So maybe you're going to start thinking about different ways. Any way you can think to cause a lot of problems for the state, where they're going to have to work and answer these things. You're going to create a record that your appellate people or that unappellate person may be really glad about actually having to brief and try to get, that's a way for an appellate person to argue all these different policy changes that are going around in the country now about juveniles and where they should be housed and why they should be housed there, and the plethora of these studies and government reports about the evils that await these kids. That's another way in which you can fashion something very creative to give to the court, and even if it's denied, you've created a very nice appellate record to perhaps have your state Supreme Court say, maybe this is cruel and unusual. Maybe this does violate the Eighth Amendment. All right. Obviously, you're going to want to try to have the least restrictive environment for your client at sentencing. You're going to want to try to see if you can get the services of a social worker. At this point, all of the information that you've gathered throughout the whole sort of case about the psychosocial history, any mental health diagnoses, any treatment needs that your client has, perhaps a social worker can find very creative ways in which to have all of those treatment needs met in the community. And again, I understand these are probably very serious charges, but you might want to also think about talking about the cost effectiveness of treating a 16 or 17-year-old and actually addressing the risk factors which got that kid into the court system in the beginning, and talking about evidence-based treatments. And again, you're really going to have to be a jack of all trades. You're going to have to understand that if your kid has a conduct disorder, what types of evidence-based treatments can you find in the community that can be given to this kid as a condition of probation? And why would the court be interested in doing that? Well, it's a really cost-effective way. There's just all manner of statistics talking about how much it costs to house children in the Division of Corrections over a 10-year period of time. I think the total is $1.2 million, as opposed to getting them community-based services that actually address their treatment needs, reduce the likelihood of recidivism, because sooner or later these kids are going to grow up and they're going to be out in the community, and if you don't address what their problems are, it's not going to get any better. All right, so perhaps a community program is not of the question, but be prepared to utilize a social worker about that and getting those treatments. You might try to, all right, you might try to look for a school in your area. If your agency or you don't have the ability to get a social worker, there are schools of social work all over the country, and they're a very good resource. You may need the judge in your jurisdiction to make specific recommendations. If you know the child is going to remain in the adult system and your state prison has a specialized programming for kids, maybe the judge needs to make an official recommendation in their order about that, or the kid can't participate. You're going to have to know that. You can ask the court to make findings about the child's specific treatment needs. If you know the kid is going to the Division of Corrections, make the court list in the order. The kid needs the following mental health things. The kid has the following diagnoses. Then that order can follow the child into the state prison system, and there may be a classification system that would affect where that child is placed. Because of their mental health needs, they may be going to a lesser secure facility. Without that, typically state prisons classify according to their crime, and that really has nothing to do with making this kid safe or providing services to these kids.
So, in terms of sentencing, and as Debbie said, you want to have the least restrictive environment. But again, why is prison so bad for kids? And like jails, there are specific statistics out there on youth and adult prisons. They are 5 times more likely to be sexually assaulted and 2 times more likely to be physically attacked in adult facilities than they are in juvenile facilities. They're also at a higher suicide rate. It's not as high as jails, but they're 8 times more likely to commit suicide in an adult facility compared to a juvenile facility. They're going to have trouble accessing physical and mental health care. They may share one doctor with, a whole facility full of adults, and that doctor will not be trained, I can almost guarantee it, in youth-specific care, which is a big deal with mental health particularly, to ensure that the youth is receiving the right treatment. They'll also be subject to the adult standards of discipline and have difficulty accessing programming. And you also, I think, at this point want to be very careful to explain to your clients the consequences of an adult conviction and the consequences of an adult record. We see a lot of youth who just want to get in, get their time done, and get out, not realizing that all that comes with a felony record in adult court. So I think really taking the time to educate your client about these long-term repercussions that developmentally they're not trained to understand, and talking that through with the youth is helpful. Now, in looking at your prison system, it's going to be a lot of the same questions that you would ask about in the jail investigation. But you want to know there, in the prison, if there's a separate youth unit for kids under the age of 18 or even 21. You also want to know what programming is available and at what point in the youth sentence, particularly with youth with long sentences. Some prison programs only kick in towards the end of the sentence, right before the youth is about to release, which means they may have 20, 30 years go by with absolutely nothing except the prison library to rely on for programming. You also want to know if there's alternative community-based placements or alternative juvenile placements that would be equipped for these youth. And investigating, where to look. Again, the same types of places that you would look for jails. I will say for prison statistics, those are generally more available than jail statistics, just because it's a more centralized system and more statewide. The prison conditions lawsuits will be likely much more prolific than jail conditions lawsuits. So that's just some tips about that. And Debbie had kind of mentioned the post-sentencing, so I just want to go to that really quickly about, ensuring that judicial parameters for treatments are followed, making sure that your client's IEP is implemented, and then any early release or parole opportunities, you want to be sure to inform your client about those. So I just wanted to make sure that we covered kind of that whole range, and then we'll come back to the sentencing and the specific arguments you can make there.
And again, we keep saying this using Graham, Roper, Miller, and JDB to challenge, not JDB, that's the Miranda one, Graham, Roper, and Miller to challenge all of the sort of the neurological differences again, the psychosocial differences of children. When adults are sentenced, the penological principles that are used have really no efficacy according to kids. And we know this for the following reasons. The principles are retribution. Well, that's kind of, it's got to be tied to the ability to enforce retribution has to be tied to the offender's culpability, right? You can't be really punitive for somebody who doesn't have as much culpability, and that's all an individualized determination. So what do we know about our kids' culpability? Well, we know from the Supreme Court that it's diminished, that it is, and that's the reason that the Supreme Court doesn't allow states to execute children. It doesn't allow states to give them life without parole in non-homicide or cases. So you can use this information, read these opinions. They have beautiful language that really takes away any penological principle to ding your kid with a really harsh sentence. Deterrence, incapacitation, they all are. We know that deterrence, that harsh transfer sentences for children have almost no deterrence on kids because they're not thinking in terms of geez, if I do this, I'm going to face the death penalty, or if I do this, I'm going to get, 25 years in prison. That's not how these kids think. And it's really your job to explain that. We're talking really fast, and I'm sorry about that. But again, on the internet, there's a motion that I filed in a case talking about the penological principles and all the ways in which, and studies in which, all cited so that you can reproduce this, that it's very interesting to look at this because that motion resulted in getting a second chance transfer for a kid. And it was because the judge needed time to sit and digest all of this information that I'm piling on him. I'm a fast talker, and I'm sort of scattered, not really focused on things, so it helps if you can give the court time to consider what it is you're saying, because we're right about this. The science tells us about this, statistics tell us about us. The U.S. Department of Justice, Bureau of Statistics, the Center for Disease Control, the Surgeon General, hundreds of thousands of AMA and APA members all agree about this. So does the judge want to be on the side that is sort of in the dark and not really looking at what the law tells us and evidence tells us, or does the judge want to be a forward thinker? And for the judge to be a forward thinker, one, they have to be educated, and two, they have to have the time to do that. There's a lovely lecture that Cathryn gave this morning on mandatory minimums. This is another area that the principles, the underlying premises about why a criminal justice system imposes mandatory minimums has no place with children. It is lost on them. They don't get it. They have diminished culpability, and they really almost are compelled to do things differently. So I encourage you to check out Cathryn's earlier webinar about how to fight mandatory minimums. If you start to think about this research and the differences that these kids have, it has implications in every single thing you do as a lawyer when you represent children. It is earth-shaking. And if you get to learn this and you get to really be an advocate for it, you have a great, powerful tool to stop really bad things from happening. And it's fun. I can remember doing this years ago when we didn't have all this research. We didn't have 3 great Supreme Court cases with lovely language in there to say, hey, judge, guess what Sotomayor says about this? That's pretty powerful stuff. I was back in the day where you're sort of scabbing up your knees and trying to explain to the court using sort of, colloquialisms and about, geez, judge, do you have kids? That kind of thing. Now you don't need to be doing that. You have the wherewithal of the Supreme Court, these huge public agencies, statistics, research, scientists, all on your side. Use it. Flex that muscle. It's a great, great thing.
I just want to make the point, too, that which Debbie had made earlier, and I just want to sort of reiterate it. We do have all of these really great studies and these really great findings and the really great language, and in some ways, that's all we need when we're making a constitutional challenge, for example, to a mandatory minimum. But when we're actually making sentencing arguments to these courts about the individual clients, and the judge has already rejected this is a de facto life sentence, or the constitutional arguments, Making sure that we present the science to the court in as, if we can have live witnesses, having live witnesses, if not presenting actual studies that are specifically relevant to your client, and then backing it up with all of the individualized information you have about your client that demonstrates that his behavior is consistent with what the science is saying and will be consistent. Because these courts are concerned about both level of culpability and being able to sort of help mitigate why they acted in the way that they did as part of it, but they're also concerned about the future and about future dangerousness and about the protection of society and about whether all the peniological goals, while they may not necessarily translate well to juveniles, they're the ones that they're statutorily required to consider. So to the extent that we can actually bring in reminding the court that this is an individual child and talking about his individual characteristics and putting it through the lens of the developmental research, but not relying exclusively on it, I think we'll have better chances at getting the judges to impose those lower sentences.
And I think too, an important a lot of what I've seen in the courts have been oral arguments about these kind of things, but really submitting it in a written motion, I think, is a good idea to really lay out, and as you've said, give the judge time to consider it, and then it's submitted to the court, and really laid out, the case for why these facilities are bad for youth in a research-driven way that then you can tie into the individual case, but really taking the time to write it out and present it to the judge. Once you have a template one, you can just crank it out. But I think that can be an important way to present the information too.
And again, your kid's individual characteristics are really significantly important here. And I'll give you a very specific example about that. We, at a sentencing, involved teachers from the jail. We were not successful in getting a kid back, but we had teachers from the jail come to court. The assistant warden came to court to talk about how this kid was not a problem. This kid was allowed to participate in this sort of special program in the adult jail. So that made a difference to the court in terms of, how much time this court felt. Like, obviously, the warden would testify that the kid felt as though, he had to do something to pay back to society for what he had done. So he was growing a garden in the inner courtyard of this jail. You could find allies and information in the most unlikely of places if you go and talk. Some of these kids, as we've noted before, spend years in waiting to come either to their trial or to a transfer hearing or the resolution of their case. So wherever they sit, it's going to make a difference how they do there. And explain that to your kid. Explain to them that their progress, their behavior matters right now, and that they need to be able to sort of muster it up as best they can. And the other thing is, when you're talking to them, they're going to not be very specific about the things that have happened to them in their lives. They're not going to want to find out, or they're not going to want you to find out about, sexual assaults, their mother did something really bad to them or abandoned them. And that's going to take time, and sometimes it requires, multiple visits to actually pull this information out of these kids. Are we done?
Yeah, let's just go. We had kind of touched on this, but I just wanted to put the PowerPoint up there so everybody can see the kind of post-sentencing advocacy issues, and just making sure that you have the right things in place, that if you do win certain parameters for your client, that those are put in place in a way that can be acted upon, by the judge in the prison for the youth. So I think we have a couple minutes left.
Yeah, I'm going to make one more well, two suggestions. One, with post-sentencing, one of the things that I've come to discover is that in a lot of jurisdictions, the prosecutor, upon conviction, will send what's called a pen letter to the facilities in which they say, this is this bad person named David, and here's the awful stuff that he did, and here's how the victim was affected. And that goes into the file, and that is what is used to help classify the placement of the client. So you may want to consider writing your own pen letter with the consent of your client, because you may be putting pretty personal things in there, but something that is similar to the mitigation packet that you perhaps presented to the court that says, this is David. Here's who he was at the time this offense occurred. Here are his, he's a special ed student. He's had mental health issues. Here are some of his strengths and things that have been, that he's demonstrated. Here are some of the challenges that he presents and what we think that you should do. And here's my request. I am requesting that you place him in a medium placement facility or whatever. It's actually stunning that some Department of Corrections will actually pay attention to this. If you have the client that is going to start out in the juvenile prison and then be transferred to the adult prison, which also exists in a number of states, that scheme, depending on what your client, if your client's in for a shorter period of time, then they may be willing not to transfer him if he's done well or if he has been subject to the programming. So there are things that you should be thinking about, both in terms of proactive things, what you can do for placement, and also things that you can do to help prevent them from going to the adult facility, recognizing that public defenders, you don't have a heck of a lot of time. Private counsel, you're not paid. Appointed counsel, you're not paid to do this kind of follow-up stuff. But some of it is relatively simple, and it really does make a difference to these children and their likelihood of future success, where they are, and for how long.
I'll say one final thing. If you can get your child, if you suspect that your kid needs an IEP, an individualized education plan, before they turn 18, that is the only thing that the adult corrections system must follow. If a kid comes into them with an IEP, the adult corrections facility has to accommodate that IEP. So that's a great thing that you can do for the kid. Maybe he gets to participate in vocational training that he wouldn't necessarily be allowed to participate in. And as you know, or may know, a lot of these adult corrections facilities, they don't have education. They may have GED classes where kids can take a GED, they study for a while and then go take the test, but there isn't an actual high school. And I think that there's a lot to be said for forcing, and this is another way to sort of get the adult corrections to start thinking about how they can perhaps either get separate facilities for these children or the money for it, or to, start advocating for policy and legislative changes about, really we don't want these kids in here. So think about those things, and even though, it requires some effort, as Cathryn and Erin suggest, it makes a great deal of difference, both on their classification, early parole, what kind of parole decisions. I mean, if the jail can't implement an IEP, that's a consideration, because then they're going to get dinged through the educational system. And it's always about the money, right? I mean, follow the money and you're going to find the answer. So just think about ways in which you can help your client. If they sent with a letter, as Cathryn suggests, because it's a terrible thing to be a kid serving that kind of time.
And with IEPs, too, I think it's important to realize that with an IEP, a youth can access services up to age 21.
That's right.
And so particularly if your kid says that they want a high school diploma, those services can take a long time depending on how behind the youth is when they go into the facility, and how much they need to catch up. So I always make sure to talk with youth about the differences between a GED and a diploma. Not that a GED is bad, but if they have the time and can get the diploma, and if that's what they want, that you can push for that for more, to hopefully get them some more services.
So, last on the IEP is that there are, if they do get it before they turn 18, that then it does follow them, and so you have some federal claims that you can raise. We have a few more minutes. I know that we had talked about possibly presenting a sample sentencing argument, incorporating some of these developmental concepts. Would you like to do that?
No.
No.
I can say this. Well, I mean, I think it's sort of laid out in the motion that is, again, attached to this webinar in some fashion, and it's laid out really, really well. It incorporates,
It's not.
It's not attached?
No, the sample motion is only going to be accessible on a members-only site because of the importance of preserving work product. So we will make some form of it accessible. So I apologize because you've been talking about it, but there was sort of a distinction between public and private access. I should say that the motion, I mean, one of the things that we should always be thinking about is taking these notions that are highlighted in Graham and Roper and Miller, the criteria that Justice Kagan put out in the Miller decision about the individual circumstances of the youth and the background and whether they have a traumatic childhood, all those things, there are reasons why she laid that out. And just being able to tie what your client did and who he is now is, will be eminently helpful when you are trying to advocate for a reasonable sentence for them.
Right, and you're going to, I mean, and I'm sorry, Cathryn, because I thought it was on there, so I wasn't prepared to do it. But off the cuff, you're going to talk about the differences that these children, what they have, and you have a hypothetical involving David, right? All of this, the peer influence that children are far more susceptible to peers. So you're going to, you would sort of stand up and talk about how David's circumstances were peer influenced. He was told to take care of a problem. He had a lot of pressure on him to do that. He was part of a group of individuals. So you're going to explain why his behavior is perfectly consistent with what the research shows us, and attempt to put those individual facts, incorporate those facts about your client in with the research and why that's important.
Well, and Cathryn, I think, made a good point, too, on our calls of, for a bail argument, for example, the youth that I mentioned earlier who was under house arrest, he was prohibited from being out of his home without supervision, and so he couldn't get involved with his friends the same way that he had before. And so even if the youth isn't kept in the jail, they can be released under very controlled circumstances back in their community that doesn't give them access to that kind of, what was referred to in the prior webinar as hot thinking, where he's really in a situation where there's stressors and friends pressure and all of that kind of thing, and that will be taken away by the house arrest or the home monitoring or him being restricted to certain very controlled environments. So arguments like that I think are helpful.
All right. Well, thank you so much. This was really interesting, and I think that the lesson, the carryaways, is it's not just the research on adolescent development, adolescent brain and behavioral development that can come to bear in bail and sentencing hearings, but it's also what we know about the facilities and the substantial research that exists that addresses the dangers that are presented to youth who are in adult facilities, as well as the benefits that are provided by having supportive facilities. There are individual things that we can do as lawyers to find out what's going on, as well as national and state-based publications, all of which will serve to educate the judge and at least get him thinking about the individual client and what his decisions, how his decisions are really going to affect that individual at each particular stage of the proceedings. So good luck and have fun.
Well, thank you to our excellent faculty. We really appreciate it, and thanks again to our partners who helped us present these series of webcasts, and to our funders, the Ford Foundation and the Foundation for Criminal Justice, who made it possible for us to present these series of webcasts for free. And a special thanks to Cathryn Crawford, who organized this series of webcasts on behalf of NACDL. We really appreciate it. So, this series of webcasts from yesterday and today will be available within the next few days on the NACDL website, along with our last series of webcasts from just about a week ago on representing juveniles in adult court at sentencing and resentencing under Miller. So that's going to be another important resource for those of you representing juveniles, and the adolescent development behavioral science webcast series that was presented earlier in the year that people were referring to. So please check the front page of the Resource Center for access to those, and also check back, because we are going to be posting some more materials and sort out issues regarding, what can be publicly disseminated and what can't. We want to make sure those representing juveniles get all the materials they need, and you will get them. It just might not be publicly posted. So you can always email me or any of our panelists and figure out how we can get you those materials. Thanks for watching.